Welcome to the Lawyers Weekly Show for an in-depth look at the issues facing the legal profession.
Hello everyone and welcome to another episode of the Lawyers Weekly Show. My name's Jerome Doraisamy and I'm coming to you today from Camaragal Land in Sydney. Today I'm very pleased to be joined in the studio by Luke Buchanan, who is the co-founder and principal of Buchanan Rees Dispute Lawyers. Luke, welcome to the show.
Thank you very much.
Today we are going to be talking about the state of affairs in disputes across the country, what's constituting best practice for lawyers in this space, and also how best to undertake a settlement agreement for your clients in the current climate. Luke, before we get into all of that, tell us a little bit about yourself and the work that you do at Buchanan Rees.
Thank you. I spent the first 23 years of my career at a large firm in Sydney. And I left with that firm about 6 years ago to start Buchanan Rees with my co-founder, Simone Rees. And I'd spent my entire career up to that point in commercial disputes, not just litigation, obviously, but commercial disputes more broadly. And that's all that we do now. Simone and I had a goal to start up a firm which specialised in that area. As a boutique, and that's what we've been doing for the last 6 years.
And why this practice area? What is it about disputes that is motivating for you?
I decided to practice law initially because I felt that law was something that was at the core of our society. It touches all areas of our lives. And the reason for doing litigation is that you always have the potential to make new law in a matter. Obviously, it doesn't always happen, but in every matter that we run, there's the potential for it to be determined by a court in a way that makes new law.
I'm interested in what you're saying there about law sort of touching, all areas, of the community around us. And it reminds me of, this idea that law is, at its core an altruistic profession in that it's a service to not just the courts and clients, but to broader society. And so there's a lot of pride to be taken in being a practitioner. Is that how you see it? Or, particularly in the disputes landscape, that you are able to make a kind of meaningful and tangible contribution?
Yes, absolutely. I think to work in law, in particular in the court system, one has to have a great belief in the strengths of the system and the fact that there are reasons for things happening the way they do. The rule of law is often cited as an example of that. It's something that people like me believe in very firmly.
And tell me about the disputes landscape right now. Obviously, there's been voluminous change across the legal services marketplace in recent times. But from your vantage point, what have been the shifting sands in disputes?
There's a lot of focus, or continues to be a lot of focus, on regulatory actions, ASIC, ACCC, APRA in my world. That, I suppose, really kicked up during and following the Banking Royal Commission. That's continued. So we're seeing a lot of work in that space. There's a continued focus on class actions as well. Something else that's grown over that same era, the last, say, 6 or 7 years since the Banking Royal Commission, securities class actions in particular. And, of course, the other thing that's becoming more prevalent now is cases to do with so-called greenwashing.
Yeah. And what kind of challenges are most prominent for you in your practice, would you say?
One of the challenges we always face is achieving an outcome for a client consistently with their cost requirements. Obviously, some clients are more able to sustain the costs of protracted litigation than others, but often we're, particularly in a boutique firm, we're dealing with clients who say, well, I've had this issue, but I don't want to run this for 3 years in the court system. So a lot of what we do is about strategizing to try to achieve an outcome which the client wants, but can be achieved within their their constraints.
Yeah. And have you found that client expectations are also shifting in the age of AI? That they will have this expectation, reasonable or otherwise, that because lawyers can use AI, that you can just get their matter done yesterday. And if that isn't the case, why isn't that the case? And why are you charging me so much? Is that something that disputes lawyers like yourself are noticing?
Yes, it's probably an extension of something that first happened that I'm old enough to remember, which is when email became the standard form of communication. And there became an expectation, I think, amongst clients, or at least some clients, that because communication was instant, that the answers should be as well. So, for example, one of the changes I've had to adapt to during my career is that if you receive an email now, even though providing the answer might be something that is quite labour intensive and involves a bit of time, you have to acknowledge that email same day, or the client will be thinking, well, did they get my email? What's happening? Are they onto this or not? AI, I think, is probably an extension of that. So part of it is about managing client expectations. Obviously, the fundamental thing is to make sure that the work is done properly and thoroughly and not rushed. But it's about managing the client expectations, that is something that you're doing as opposed to leaving them in limbo.
What are some of the other lessons that you've learned over the years, along the lines of the advent of the internet, the advent of AI, and having to pivot and adapt so that client service delivery can remain at an optimal level?
I think all of those tools are tools that the clients expect you to be using. But at the end of the day, the fundamental question, as I said, is about getting the answers right. And I think clients accept that the law is something on which reasonable minds can differ a lot of the time. That's why you have a court system with judges and appeal courts, and then sometimes a second appeal court if leave is granted to go all the way to the High Court. So clients accept that, but they want to know that you have considered everything and turned your mind to everything that you should have in providing them with advice. The other thing that I would say is key that I've picked up over my career, and I always try to do, is you have to stick your neck out and actually make a recommendation. You can't just say to a client, well, you have options A, B, C and D and there's problems with all of them. You need to say, well, we recommend option B and these are the reasons why.
Yeah. We're chatting with Luke Buchanan, and we'll be back with more right after this. So, Luke, the crux of our conversation today is about settlement agreements and what is constituting best practice in the current climate. Now, for those who don't work in the disputes world, could you give us a brief refresher on what a settlement agreement is?
Yeah, sure. So a settlement agreement is, or deed, is a contract. And so, like any other contract, there are rules that apply to its formation and rules that a court will apply in construing the agreement. The difference between a settlement agreement and any other type of agreement, of course, is the subject matter. A settlement agreement or settlement deed, the subject matter is settlement of a dispute.
And how much has the landscape shifted with regard to settlement agreements over the years? Have we seen big legislative or regulatory change around how these should be reached, or has it been has it been more of a constant over the years? Broadly
speaking, with one exception that springs to mind that I'll come to, it's been pretty constant because, as I said, it's really a matter of contract law in terms of how the agreement is formed and how it is then construed by a court. The exception that springs to mind is in class actions. Ordinarily, a settlement has to be approved by the court. So that's something which I mentioned earlier. There's been a growth in class actions over the course of my career. That's something which is a relevant, I suppose, differentiator in the class action space.
And just on that point, I mean, given the rise of class actions, and I don't think there's anyone out there saying that we're going to be seeing a decrease in the number of class action filings in the coming years. And you can correct me if I'm wrong on that, but I certainly haven't seen any reporting on that front. Do we expect, or can we anticipate that perhaps the nature of settlement agreements might shift. If we're seeing more and more of those types of proceedings and agreements needing approval.
I wouldn't say the nature of settlement agreements might shift, but certainly the level of scrutiny applied by the courts in a class action environment where the settlement does need to be approved by the court. I think the trend at the moment is for that to increase. For example, normally the settlement agreement in a class action will involve agreement as to how much is to be retained by the lawyers who've acted in the matter, payments to litigation funders, that sort of thing. I think we are seeing a trend where courts scrutinise that sort of information quite closely. It's not a rubber stamp.
And why are the courts doing that?
I think primarily it's about fairness to class members.
Yeah, no, fair enough. And given your sort of years of experience, having worked in this front, what would you say are the hard and fast rules or steps that lawyers need to undertake in order to reach a settlement agreement? Are there kind of black and white rules here, or is it kind of case by case depending on the client matter?
Well, coming back to something I mentioned earlier, because a settlement agreement, or it can be a deed, as I said, is a contract, there are really a few key things that apply to the formation of one. One is, of course, you need offer and acceptance. Two is that you need consideration, with the exception that if it's a deed, no consideration is required. But normally there will be one in a settlement because normally a settlement involves compromise on each side. And the third requirement is an intention by the parties to be legally bound. On that third requirement, it's pretty clear if it's a deed, a formal deed or formal agreement, that intention is present. Sometimes, however, you have something in writing, but perhaps less formal, like something called a heads of agreement or a terms of settlement. It's up to the parties whether they make them legally binding or not. But ordinarily, if you enter into one of those as a means of documenting the settlement, the intention would be that it be binding. It's important, I think, from the lawyer's perspective to ensure that if that is the intention, that is expressed in the document so that there can be no doubt afterwards that it's meant to be binding, for example, immediately upon signing.
Yeah. Well, certainly it sounds important to have that kind of safeguard in place. What are some of the other common stumbling blocks or hurdles that you might come across in trying to get clients and the opponents from A to B?
Yeah, so I think, and this comes back again to something we were discussing earlier, but fundamental to the way we approach things is that clients don't exist to litigate. Some of them are more litigious than others, of course, but it's never part of their core business. Therefore, if they're involved in a dispute and the instructions are to settle that dispute, their interest is ensuring that the settlement is final so that it brings an end to the litigation or whatever dispute forum they're in. So the mistakes that I've generally seen involve agreeing to a settlement or documenting a settlement in a way which doesn't produce absolute finality. So the key things are you need to be abundantly clear in relation to what is being settled, on what terms, and what is the agreed timing for those terms to be complied with. So in terms of what is being settled, you need to cover all aspects of the dispute. If they are the terms on which the parties are agreeing. In the context of litigation, that's usually pretty obvious because it's everything that's the subject matter of the litigation. But if you're in a pre-litigation context, there can be all sorts of allegations and disputes floating around. Unless everybody's abundantly clear that aspects are not part of the settlement, then the settlement document, be it an agreement or a deed or a terms of settlement or a heads of agreement, needs to be very clear as to what is being settled. And normally that will be everything that's in dispute.
You mentioned the idea that clients want whatever dispute is occurring to be final. They don't want to revisit these matters, with those on the other side of the table. What are some of the other observations you've made over the years regarding client motivations or or desires or non-negotiables that have really informed how you look to guide clients through these proceedings?
Yeah, well, one of the things that springs to mind as you say that is that sometimes there can be, as I said, a bunch of different things that are in dispute, or at least different aspects of a dispute, and some of it's pretty simple and easy to resolve in terms of how you document the terms. There are other things that can be other things that clients sometimes put in the too hard basket and say, we'll deal with that later. And so there can be suggestions that you incorporate into a settlement document, what we call an agreement to agree. An agreement to agree is not something that's enforceable by the courts. The courts won't enforce a clause that says the parties will agree something down the track. So as much as it might be a difficult thing to do, I would always recommend that clients grapple with all of the issues at the time of documenting the settlement and thrash out a way through and a way of resolving every aspect of the dispute in the settlement document, because kicking the can down the road can lead to problems.
And with some of the technological change that we were alluding to earlier, obviously almost all contracts these days are signed electronically. Particularly if you're in the property space. How have some of these evolutions changed the nature of the work that you might have to undertake with settlement agreements? Or is it just literally going from pen and paper to doing it online?
Well, as you say, a settlement agreement, like any other contract, can nowadays be executed electronically. Ordinarily, what happens in that circumstance is that there's a clause in the document providing for that to occur, and in substance saying that if a party executes electronically, that party is bound just as they would be if they'd executed in wet ink the old-fashioned way. That's certainly a change that I've seen in recent times, and really it comes back to the third criterion I mentioned earlier that the courts will look at, which is, well, did the parties intend to be bound? And if there's sufficient evidence of that, then the court will hold that the agreement is binding and enforceable.
And with some of the other ways in which technology is evolving, such as, obviously we've spoken about email, but also, there's emojis, through text messaging now. Are we at a point where courts are going to start inferring from those kinds of communications as to whether or not someone intends to be bound? Like, for example, if you send the thumbs up emoji?
There's certainly the possibility of that, because the court, it's really about whether the court is persuaded on the weight of the evidence. And of course, in civil law, the test is the balance of probabilities, whether the parties intended to be bound. Emojis and things like that will become more common in court cases, I suspect, and it's just about whether the judge feels that that the evidence is sufficient for a finding that the party that sent the emoji was intending to be bound. And I should say that is one key difference between an agreement and a deed. An agreement can be written, of course, but it can also be oral or implied. I'd never recommend settling a dispute in a way that's purely oral or can only be implied from the surrounding circumstances. But in theory, agreements can be any one of those three, whereas a deed must be in writing.
Yeah. So with some of these developments, that we're seeing, with technology and the social landscape, I mean, do you as a disputes lawyer have to reconfigure, how you look to approach your interactions with clients, and perhaps advise them to be, cautious about some of the communications they might be sending?
Yes, absolutely, and you see it more and more. Stepping outside the settlement agreement context for a moment, you see it more and more in the context of obligations to produce documents in litigation, things like discovery or subpoenas, notices to produce. They can capture not just emails and letters and traditional forms of written communication, but things like text messages or messages on WhatsApp or Slack or one of those platforms.
Yeah. Some of these changes, are there any looming changes that we are able to anticipate, be it in the regulatory space or the legislative space or even in case law that, you're looking out for right now?
I think in terms of seeking documents from other parties, we're always now keen to ensure that we broaden what is categorised as a document, what's court. I mean, there is a definition of that in the Evidence Act, which is quite broad, but you never want to leave anything out. The other thing is, of course, in advising clients what sort of documents they have to retain for the purposes of litigation. We need to make sure that we capture all those types of things that I've mentioned because I don't communicate with clients on WhatsApp or Slack, but I know clients communicate with each other on those message platforms.
Yeah.
And so, yes, all of that is discoverable.
Yeah. Luke, I've just got a few more questions for you, which we'll get to on the other side of this. So, Luke, further to my previous question, how do you see the landscape for settlement agreements shifting, in the years to come, and what does that mean for a disputes lawyer like yourself?
I think the cost of litigation, as much as there've been efforts to rein it in over time, it's still a very expensive exercise, and so the percentage of commercial cases that settle before trial or even during trial has always been quite high. I expect that will continue. So what that will mean is that, again, coming back to something I mentioned earlier, clients who want to reach a settlement will need to have their settlement documented in a way that brings it to a final and binding conclusion. There is a case that goes way back to 1956 in the High Court, Harvey and Phillips, where what had happened in that case was that the parties had attended a settlement conference. They had reached a settlement. They'd informed the court about that. The court had actually congratulated the parties through their lawyers on reaching a settlement. The plaintiff then alleged that the agreement was not binding. Basically, she had colloquially what we call buyer's remorse and wanted to resolve from the agreement on the basis that she said she'd succumbed to pressure to settle. What happened in that case was the court held that the settlement agreement had been entered into in circumstances where the legal representatives for the parties, including the plaintiff, of course, had actual or apparent authority to settle, and therefore the plaintiff was bound. What we have now is Section 73 of the Civil Procedure Act, which provides that the court has the power to determine questions regarding compromises and settlements. That's the Civil Procedure Act 2005 in New South Wales. The rationale for that, of course, is that settlements are to be encouraged, and it's designed to avoid a settlement falling apart completely if one party does have buyer's remorse and later wants to resolve from the deal.
Yeah, well, I guess even in the face of so much market change and technological change, some things remain constant. One of them being that settlement is always a preferred option, no matter what the dispute is. So, Luke, in the face of all the change we've discussed, and also some of the things that remain constant over the years, how has your view on what constitutes best practice with settlement agreements changed over time? Have your views stayed much the same when it comes to best practice in serving clients, or has it shifted?
I think one of the things that I've started to do more is use what I'll call a truncated form of document, like a terms of settlement or a heads of agreement. As I said, it's important in that scenario to ensure that it's expressed to be legally binding. But I think it's a very useful approach where a settlement occurs, for example, in a mediation or even an informal settlement conference, and the parties are all sitting around the table. You want to have it documented in a way that is binding before everybody leaves the room to guard against the possibility of one of the parties changing their minds later. But it can be very time-consuming to negotiate the terms of a full deed, or settlement agreement, which might be 8 to 10 pages. Something that's a couple of pages, which documents the key terms, and everybody agrees to be bound by those terms, is very useful in that scenario, and that's something that I've started using more frequently.
Luke, just finally, what excites you about your work in this space moving forward? Whether it's settlement agreements or just disputes work in general.
I've always got, to be honest, a real buzz out of going to court. When I was younger, there was the opportunity to do, even as a solicitor, quite a bit of advocacy work. Now that happens less frequently, but even going to court instructing counsel is something that I really enjoy. And obviously in a matter that settles, that doesn't happen on a final hearing basis, but there's interlocutory steps along the way. And in a matter that settles, it's really good to just achieve an outcome that the client is happy with. By definition, if you get a settlement, it's something that the client has agreed to and therefore something that they want. So it's great to have a happy client at the end of the day.
Yeah. Luke Buchanan, thank you so much for your time.
Thank you.
And thank you to the listener for tuning in. We hope you enjoyed this episode. If you did, please give us a rating and review on whatever platform you use to listen to podcasts, as it'll help other lawyers discover and enjoy this show. We'll see you again next time.